Corner, June 29th. Oh, we're getting close. We're getting close. 2026. June 29th, 2026. How's everybody doing out there? Say hi to everybody over here on Telegram right now, anyways. Michael Casper, good to see you. Paint Gun Spooty, Kathy Watson, good to see you, dear. Prayer Word, good to see you, dear. And we're live on YouTube. Any big plans for the 4th of July, folks? Jim Valentine, good to see you over here. Telegram. And nobody over on Rumble yet, huh? I'll wait. There's a couple people over there, but there's nobody chatting yet. Kathy Watson, you're going to be the firecracker you are? Right on. Leah Munson, good to see you over here. Yeah, we'll wait for some more people to get on here because I don't know. We'll see what's happening here. Let's see anybody on Facebook, X, or any of that. Where's Wendy at? Jacqueline. Diesel D's. Solely Mart on YouTube. Black Mountain, North Carolina. Well, welcome. There's Jax. Uh-oh, Rumble's not working? Oh boy. Now what the heck? Michelle Atkinson, good to see you. You're from Idaho. Your name sounds familiar. Anybody from Facebook or X? Munson 58. I'm not sure about the John Bolton case. I haven't followed any of that. All caps false prophet. Good to see you. So it's working. Rumble's working for some. Oh. Yes. Okay, Michelle. Now I know who you are. Why it sounded so familiar. I've been so freaking busy, it's not even funny, but good to see you're here. TLM 592 over here on Telegram saying Rumble is working. Palindrome. Wendy, you made it. Working for some, but not for others. Well, you're going to like this one a little bit about what I'm going to share tonight. I'm going to go back over the State versus Clark case, Idaho case in 2019, the Idaho Supreme Court, because there's more to it. Mark Bond, good to see you, brother. Jacqueline said she's Rumble's not working for her tonight, so. Oh, well now it's working for you, huh, Jacqueline? Let's see how long it decides to work tonight. Now I did update my broadcasting software after Monday Night Law last week. Slim Frank, good to see you. Well, before we get into the State versus Clark case, I want to play this video. Let's see. I know this actually came out a few days ago, but I do want to play this here and listen carefully to what's being said here.
Oh, we're watching history play out here, John. It's remarkable. People haven't figured it out. We're already in a series of what I call a sequence of events. In this, if we back up a little bit with the trip from the King and Queen to the White House, Donald Trump goes to China. He had some meetings there, some of which is not disclosed yet. He leaves China, and Putin flew in the following morning. I think they were signing agreements. But Donald Trump gets back here in time for the 17th of May to launch a day of prayer, which coincided with the same day that George Washington offered a prayer for our nation. And it was 49 days, 7 times 7, before the 4th of July. So all of this is structured out. We are in the sequence of events, and it's not going to be altered. This is a military plan that has been executed to lay this out. So the country has been encouraged to pray for 10 minutes, minimal a week, for the country leading up to the 4th of July. On the 14th, we had the UFC fight, of course, on the South Lawn at the White House. And we had incredible things that occurred there. Not only was it a great event, and we, as has been indicated by Rob and Tom, that we had a consent of the government that took place. But the amazing thing is the miracle of the storm. You have a storm heading directly for the White House. It's all red on the radar, and it literally splits in half, goes around the White House, and comes back together, leaving the event unscathed.
Now,
Was this a coincidence? I don't think so. You literally had heaven given its blessing upon the events of that day, and 10 days following that day is tomorrow, of which we're going to have the rally of all rallies on the Mall in D.C. to kick off the Great American State Fair, of which 10 days later is the 4th of July. So 2 10-day sequences leading up to the 4th of July. You get past the 4th of July, another 10 days, and now you're in the sequence of time when the prize floors of medals are supposed to be kicking in. We are literally walking through history here. And I think the amazing thing is we have such a dead media that nobody wants to cover the significance of these events, but they're so huge, and they affect the entire planet. It had to be won here. America had to win it first for freedom to go across the globe. And we are retaking that. We're actually winning something we didn't even win before, and that is complete and total sovereignty. Because for a long time we've been under this idea that we've been free from England. But as many of us know here on this panel, they've always had to clutch us into this country.
That's right.
And what they did with the corporation and over since 1871 till now has all been about the subjugation of constitutionality, placing us under what is essentially, in every definition of the word, fascism, the corporatization of government. And so it's incredible what we're walking through, because we're literally breaking the shackles of this corporate governance, this fascism, and we are restoring our constitutional sovereignty. It's unbelievable. Oh, we're watching history play out here.
Things are happening, whether people believe it or not. There are significant things that are happening that are timed precisely for a reason.
Later is the 4th of July.
So, what's going on there? I'm not going to say either way what is really going on there, but there's a significance to the dates, okay? And the fact that it's basically repeating history. Some of the things that have to be done in order to take this crap down. And that, yes, we've been under British rule, Roman civil law, the code, right? They just could not leave it alone, right? They can't leave us alone to have our laws of nature and the common law as our fundamental law. So, all right, cool, good that Rumble's working for everybody out there tonight. Now, good to see you, Regina. So I just, I've seen some people talk about all this. Oh, it's all just hopium, blah, 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 blah. This is much bigger than most people think or are even aware of. I mean, again, this has been a military operation worldwide. And, I see people talking about trust the plan, this is all just hopium, and it's, we're supposed to just sit around and wait. No, well, it's not. They're not coming to rescue us. Trump specifically said at his inauguration speech in 2017 that he was putting the power, he was giving the power back to the people. All political power is inherent in the people. Now, I threw out a post earlier this morning about the Constitution, our right to petition, and how it talks about all political powers inherent in the people, and the legislature is the one with the authority to revoke privileges. And I've talked about this one before. Hale versus Hinkle uses the same exact words and says there's a reserved right in the legislature to do an investigation into these corporations to see if they've exceeded their authority. Our right dictates this process. And again, I repeat, our right dictates that process. Right directly from the Declaration of Rights in our Idaho Constitution, and every other state constitution has the same exact verbiage. So, when are we going to learn that that's how our true Republican form of government is supposed to work and function, and how we, the people, claiming and exercising our rights for a redress of grievances, that's the remedy, is in the legislature, not the judicial. So, when are we going to learn that? When are we going to learn that claiming and exercising the right of political power is done through the legislative branch? And then when are we going to start doing it? And again, as of right now, this is that provisional government pending the outcome of the war, which Texas v. White refers to pursuant to Article 4, Section 4, that the president, only acting as commander-in-chief, has the power to set up provisional government pending the outcome of the war. So there are things, the executive order, 14288, where Trump deployed the military to the states to eradicate all crime. And Section 4 of that executive order puts the power into the state attorney general's hands and allows the people to file public corruption complaints. Okay? I'm very well aware that the whole system is corrupt, but that's not an excuse not to do something. That's what's been put in place for us to tell on them. Okay? Normally we would just file a criminal complaint. Right straight into our justice of the peace or the district court, and we would take the stand. We would testify under oath. Then they would, make the commitment to prosecute, and we get sent over to the prosecutor, or would be sent over to, technically speaking, to assemble a grand jury. That's actual process. Supposed to be done through a grand jury. But this is just what we're supposed to do. This is what's been put in place for us to utilize to take down the corruption. What? He wants everyone to file with the DOJ and AG for retail fraud on the gas station price gouging. Yeah, you're right. I did remember him saying that, talking about to report price gouging at the gas pumps. Now, here in Idaho, I have been noticing the gas prices dropping pretty crazy. It's now under $4. I haven't been out today to see if it's dropped any more, but it seems to be dropping like every day. So wasn't able to find public corruption section at Attorney General Texas. Well, let's just see. Here's Attorney General complaints overview. Well, in what circumstances? Well, this is done by executive order, so I'm not sure why the Attorney General hasn't well, there you go. Victims of crime. Find services and resources to support your recovery, including compensation, safety, and guidance. I wonder if it's under the consumer protection. Let's go here first. Yeah, it's more towards businesses. Yeah, I can't believe that they don't have an actual public corruption complaint, because that is pursuant to Trump's executive order. But nonetheless, even if there isn't an online one, you can still report these crimes to regarding the public servants to the Attorney General, whether or not it's here online and doing it through online. The executive order stands. So and I'll just bring that up. Because that was there it is. Because I know that was in May 2nd when it was published. Go. Why is it not going? There we go. One 14288. Right there. Strengthening and unleashing America's law enforcement to pursue criminals and protect innocent citizens. Now the 87 one, that's the deal with the alien stuff. we get down here to Section 4. Use your national security assets for law and order. Within 90 days of the date of this order, the Attorney General and the Secretary of Defense, in consultation with the Secretary of Homeland Security and the heads of agencies appropriate, shall increase the provision of excess military and national security assets in local jurisdictions to assist state and local law enforcement within 90 days of the date of this order. The Secretary of Defense, in coordination with the Attorney General, shall determine how military and national security assets, training, non-lethal capabilities, and personnel can most effectively be utilized to prevent crime. Oh, it's actually Section 5. Holding state and local officials accountable. The Attorney General shall pursue all necessary legal remedies and enforcement measures to enforce the rights of Americans impacted by crime and shall prioritize prosecution of any applicable violations of federal criminal law with respect to state and local jurisdictions whose officials willfully and unlawfully direct the obstruction of criminal law, including by directly and unlawfully prohibiting law enforcement officers from carrying out duties necessary for public safety and law enforcement, or unlawfully engage in discrimination or civil rights violations under the guise of diversity, equity, and inclusion, initiate initiatives that restrict law enforcement activity to endanger citizens. It's kind of vague there, but the part there is it talks about civil rights violations. It's been put in place, and should already be part of the Attorney General duty to prosecute public servants anyways. Like that's already basically part of our Republican form of government. Remember, it's supposed to be of the people, by the people, for the people. And I know that it's been most often misconstrued. Well, the Attorney General, he defends the state. No, you're supposed to prosecute. You're a prosecuting attorney. So, yeah, but the thing is this is what Trump has put in place for us to utilize right now. And no, Slim Frank, do not complain to your Congress or state legislature. It's called a petition. Do not email, do not phone calls, none of that crap. It must be a petition. That's a political lawsuit. That is what our right dictates. In fact, I'm going to go back to that. Well, maybe. If it will let me. There you go. The post that I made, my brother Rob made some comments on my post there. And he has shared that with me before. I'm on. Where was it? This one, I think it was. No. Oh, it's in the comment there. It does. Right here. Another reason why no action should be taken by the Legislative Assembly, and which leads me to believe that no good cause exists for its repeal, is the fact that no petitions have been presented upon the subject, which could not have been the case if desired by the people, as it is a subject in which every person has a vital interest. So, if we're not filing petitions, they don't have to do anything. but you know, that this is the problem, right? Nobody's following what our right dictates, right? I mean, I've covered this so many times it's not even funny. I mean, this was the early onset of what Christopher Hallett and I joined together. Oh, now we're having a problem getting to my Idaho Constitution. Come on. Well, I posted it on here. That's what this is. The exact verbiage. So, Article 1, Section 2 says political power inherent in the people. All political power is inherent in the people. Government is instituted for their equal protection. Excuse me. And benefit. See, right? Government is instituted for our equal protection and benefit. And they have the right to alter, reform, or abolish the same whenever they may deem it necessary. Now, this is the part right here. And no special privileges that Hale versus Hinkle refers to precisely, or immunity shall ever be granted that may not be altered, revoked, or repealed by the legislature. Everybody see that? By the legislature. This means that the legislature has the power to investigate and revoke, and I was specifically referring to the CPS powers because so many people are complaining about CPS and something should be done about it. It's right there. Okay? So, what is the process to achieve that? Section 10, right of assembly. The people have the right to assemble in a peaceable manner, to consult for their common good, to instruct their representatives. Well, if we have the power to instruct them, that means we're the masters and they're the servants. And to petition the legislature for the redress of grievances, not the judicial. Both Section 2 and Section 10 specifically state to the legislature. It's not a remonstrance. And Guinevere, asked John Gentry, who, didn't know at the time the proper form of a petition. We didn't discover that Lex Parliamentaria Americana. I didn't discover it until after Chris was murdered. November 15th of 2020. But Lex Parliamentaria Americana lays out all the elements of a proper format of a petition. And on my website, kirkslawcorner.com, I have a document template that I did in the proper format of a petition. Although that one is to Congress, doesn't change the fact. Well, the Fix It Fast, which is good to see you fix it. I'm glad to see you here. But the petition in proper form has a statement of facts. Here, let's just go over there real quick. I'll pull that sucker up and explain this just real quick. Right there, petition tab. Okay, this is in diploma font, which is the way it's supposed to be done. Who it's to the Honorable General Assembly. Imagine that. And I put in here pursuant to Section 4, Article 4, Section 4, and I would be pursuant to Article 1, Section 10. Here's the statement of facts. Okay? There is a foreign invasion happening on the southern border between Mexico and the United States of America. Okay? This is the statement of facts. This is basically your affidavit. Right? This is how it's done. This is the proper format of a petition. And then you have a prayer for relief. And this is where we make our demand. To create a committee and open an investigation to verify claims 1 through 3. Okay? To declare war pursuant to Article 1, Section 8, Clause 11 for foreign invasion. Notice that I'm citing law of the land. Supreme law of the land. To call forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions pursuant to Article 1, Section 8, Clause 15. We, the petitioners, and all undersigned, humbly submit this petition on October of the year, and it's notarized. Okay? This is the proper format of a petition, not a remonstrance. They are two different things. No, it is not a remonstrance. This is a petition for the redress of grievances. Remonstrances are about legislation being made, and it's a formal written protest to that legislation. Okay, you're saying, hey, I do not support this legislation, this bill, what have you, because there is no prayer for relief. My Dogger 3X or whatever your name there is out there on YouTube. Invasion from within. It's not invasion. It's called domestic violence. That's internal insurrection, an attempt to overthrow the Constitution and war against the people. That's what domestic violence really is. Pursuant to Article 4, Section 4. Not this new made-up shit domestic violence, which has to do with domestic relations, and the Violence Against Women and Children Act of 1995, which it's already been, parts of it have already been declared unlawful and unconstitutional, U.S. versus Morrison, in 2005. So, it's unlawful and unconstitutional to begin with because Congress has no authority to redefine what domestic violence is, let alone do the Domestic Violence Protection Act. They don't have that authority to alter the fundamental law, to make any process due process of law. So, just so everybody's aware of that, you know, this is the proper format of a petition, straight out of Lex Parliamentary Americana. Elements of the law and practice of legislative assemblies in the United States of America. That is the common law book. And I know that's one of the questions I've been asked over the years is, well, where can we find the common law? There you go. There's one book that has the common law. The other one, and the ones, is Blackstone's Commentaries on the Laws of England, which we're going to jump over to that State versus Clark right now, so I can show you that. Because the United States, was that New York State Rifle Pistol Association versus Bruin case, specifically cited number one citation. The first thing they went to was Blackstone's Commentaries on the Laws of England. Here in Idaho, in 2019, going back into the, well, we got to do, we got to go back to what the common law was at the time. Well, why did they go back? Why do they have to go back to the common law? Because the common law is the real law. Provisions of the Idaho Constitution must be construed in light of the law prior to their adoption, because the constitutional guarantee against unreasonable seizure and the person includes an arrest. The Idaho Constitution incorporated the principles regarding arrest in the Idaho statutory common law in 1890 when the Constitution was adopted. See, look at this. Because, talking about the Idaho Code, because these subsequently enacted arrest standards did not exist at the time the Idaho Constitution was adopted, and because they were not incorporated by constitutional amendment, they cannot be considered part of the constitutional standard for what constitutes a reasonable seizure of the person. As a corollary, Green held because the Constitution guaranteeing against another assertion of the person includes an arrest, the Idaho Constitution incorporated the principles regarding arrest in the Idaho statutory and common law in 1890 when the Constitution was adopted. When construing the Idaho Constitution, the primary object is to determine the intent of the framers. Well, yeah, that's the people. So we must now determine the meaning of the language used in as that existed at the time the Constitutional Convention was in session. We have explained the significance of case law and statutes existing in 1889 as follows. Blah, 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 blah. Doesn't matter. Thus, a review of the common law is in order. Not a review of case law or statutes. No, a review of the common law. What is the first thing they cite? Blackstone's Commentaries on the Laws of England, Book 4, Section 289. The constable hath a great and original inherent authority with regard to arrests. He may, without warrant, arrest anyone for a breach of the peace and carry him before a justice of the peace, and, in case of felony, actually committed, or dangerous wounding whereby felony is like to ensue, he may, upon probable suspicion, arrest the felon. Oh, so you can only make an arrest without a warrant for a breach of the peace and take him before a justice of the peace, and in a case of a felony. If that's not quite clear enough for you, their second source of the common law, a scholar of the common law, wrote, there were, and indeed still are good many differences in the considered importance of procedure relating to the prosecution of felonies and misdemeanors, respectively. The most important are that. Notice that this is italicized. This is quoting directly from the source, which is Stephen, History of the Criminal Law of England, 1883. As a rule, meaning rule of the common law, a person cannot be arrested for a misdemeanor without a warrant. That's the rule of law, which coincides with exactly what Blackstone says, what the common law is. It's pretty simple. This is what the Fourth Amendment means. The right of the people to be secured in their, and it's the right of the people, not the right of the citizens. It's the right of the people to be secure in their persons, papers, houses, and effects. What? Shall not be violated. And no warrant shall issue, but upon probable cause supported by oath or affirmation. Oh, if you've got probable cause, great, go get a warrant. Because unless you have a warrant, you cannot make an arrest without one. The exception to the rule is for a felony or breach of the peace. Oh, that's the law. I could care less what the Idaho Code says. This is the common law of the land, the supreme law of the land, not Roman civil law, the code. Okay? Plain and simple. That's the law. Now, just to reaffirm that right there, because we're going to go right here. The common law, as it developed throughout the United States prior to 1899, appears to have been unanimous in agreement with that articulated above. So there should be no question of law here of whether or not anyone can be arrested without a warrant, except for felonies or breaches of the peace. That is the letter of the law, the rule of law, the common law. That is the law. And again, this goes back to Trump and his proclamation reestablishing the rule of law. This is why they're having to go back and do a review of the common law. Again, this is not a statute. This is not case law. This is a review of the common law, because that is to be the law. That is our fundamental law. It's right in the Northwest Ordinance, 1787. We are to have common law. It's in the Organic Act for the Territory of Idaho, Section 9, to possess chancery as well as common law jurisdiction. That's it. We're talking about rights as the law. These are not constitutional rights. This is the common law, which comes before the Constitution. I know a lot of people don't understand that. But declarations of rights and bills of rights, and those merely declaratory of the common law, which is American Jurisprudence, Volume 16, Constitutional Law, Section 100, the bills of rights are for kings. Declarations of rights lay down the law. And all throughout history, declarations of rights were separate from the Constitution, because the Constitution is supposed to be the instrument of government. But how about this one? A peace officer has no common law power to arrest without a warrant on mere suspicion of a misdemeanor, although he may do so for a breach of the peace or misdemeanor less than a felony committed in his presence. No, that's case law. No, the common law says you cannot make an arrest without a warrant except for felonies and breaches of the peace. But that would be the see, they put in or misdemeanor less than a felony committed in his presence. Nope. You cannot make an arrest without a warrant, even if it is a misdemeanor. It does not matter. That's not what the common law says. And that totally subverts the Fourth Amendment in Article 1, Section 17. The right of the people to be secure. To be free from unwarranted and unwarranted arrests without a warrant. Slim Frank, when it comes to the petitioning in the legislature, that whole thing about the assistance of counsel and that's all they're placating the game of the judicial branch, right? So Of course, anybody can draft the petition for whoever and have them sign off on it. But I think everybody needs to learn how to do this for themselves. I mean, this is our rights. We need to learn how to do this. How to claim and exercise our rights following due process of law. So, clearly what they said here, the common law as it developed throughout the United States prior to 1889 appears to have been unanimous in agreement with that articulated above. I don't care about any of this case law. None. This is all trying to subvert that, saying, oh, well, they can make an arrest without a warrant for a misdemeanor. That's not what the common law says. That's not what Blackstone said, not what this scholar of the common law, Stephan, wrote. He said that as a rule, a person cannot be arrested for a misdemeanor without a warrant. Period. I mean, that there is no ifs, ands, or buts. There is no saying, well, we're going to say that they can. No. We, the people, laid down the law and said, no, you cannot. See? 1853, 1879. Yeah, for a breach of the peace committed in their presence is conceded by all. Now, I again, see how they're trying to say, oh, it was committed outside of his presence. Because that's what this particular case was. And that's, well, I'm familiar with the merits of the case. I don't care what the merits of this case is. They're citing what the law is, which is applicable to all cases at all times. And again, it's funny because this is what I cited in my memorandum of law in support of my motion to dismiss and motion to suppress. But I'm going to get down here to some more because where is that? Notwithstanding this challenge in the common law of Maryland, 2 decades after our Constitutional Convention, the United States Supreme Court continued to recognize the traditional common law rule in John Bad Elk versus United States, stating that an officer at common law was not authorized to make an arrest without a warrant for a mere misdemeanor not committed in his presence. See, they're talking about not in his presence. But see, what other misdemeanor is there? Oh, you mean all these shit made up bills of attainder? Well, what was the John Bad Elk case? Anybody know what the John Bad Elk case was? John Bad Elk is the one who shot the 2 officers who came to his house there, tried harassing him and wrangling him. First it was to get him to come see the sheriff because he had discharged a firearm in city limits, right? And word got to the sheriff. Sheriff sent a couple deputies over there to ask him if he would come talk to the sheriff. And the first visit was, hey, I'm busy taking care of my mom, taking care of the farm, whatever. I'm busy. I'll go talk to the sheriff later. And later came and he didn't show up, so they went back over there to harass him again. And they tried putting their hands on him. And so he was packing armed, and he drew up his arm and defended himself. They didn't have a warrant for his arrest. He shot and killed him. And the court said, no, you didn't have a warrant. You were trespassing. He had every right to defend himself because you did not have a warrant. That's the common law, folks. So even in 1915 in Idaho, State versus Mox, 1915, and we implicitly continue to apply the common law rule. There, the defendant complained that a jury instruction assumes that a person may be arrested without a warrant for a past misdemeanor not committed in the presence of the officer performing the arrest. So they're really trying to make it about, well, it's about a past misdemeanor. Was it explaining that the jury instruction does not assume the law to be that any person may be legally should be lawfully, because we're talking law, arrested without a warrant for a past misdemeanor not committed in the presence of the officer performing the arrest, but it tends to instruct the jury that if the constable had reasonable cause to believe appellant was committing or was about to commit a crime, it was his duty without a warrant to endeavor to prevent him from committing it and to arrest him, even though he had completed the offense before he could be prevented from doing so. But in my case, there was no misdemeanor. The only misdemeanor was resisting and obstructing. So, how is it resisting it? Where's the lawful arrest? Not having plates on my car is alleged a traffic infraction, which is a bill of attainder. Because crimes are either felonies or misdemeanors. There's no such thing as an infraction. That's foreign to our form of government, foreign to our Constitution, and unacknowledged by our law. Our law is the common law. So, because of the way this guy argued the case, that's why they're saying that prohibited warrantless arrest for completed misdemeanors. We are fully mindful of the significance of this conclusion. Domestic violence is a serious crime that causes substantial damage to victims and children, as well as to the community. But when we're talking about domestic violence, isn't that assault or battery? The common law covers that, assault and battery. Yeah. Nevertheless, the extremely powerful policy, what? Policy? It's not law? Considers with support upholding Idaho Code? Policy must yield to the requirements of the Idaho Constitution. For this reason, we vacate Clark's judgment of conviction. In light of this decision, we do not reach Clark's remaining claim of error. But they vacated it because they made an unlawful arrest without a warrant. They illegally searched and seized him. Right? Jennifer, possession of a case file where someone filed pro se documents and lost the case. Instead of proceeding with an appeal, they left the door wide open, using the case unjustly against others. Yeah. That's the problem. But yeah, I'm definitely challenging this. So at least this case, they're saying, well, yeah, you can't make an arrest without a warrant after the misdemeanor was completed, even though that's not what the rule of law reads, as it is written. So I guess I'm going to have to take this all the way up to the Supreme Court and I'll just cite this right here. I mean, we don't even, this is the common law. You cannot make an arrest without a warrant. I mean, why even have the Fourth Amendment, Article 1, Section 17, if you can make an arrest for a misdemeanor? No, you cannot. But that's the thing. See, they've created, right? They've created crimes. They created these, well, that's a misdemeanor. No. Where's the injured party? Because, again, where's the injured party? Come on. Let's see. Is it gonna let me do it tonight? Yeah, something's going on. It's not wanting to let me get into to either the Constitution or the Idaho statutes. Let's see if I can do it the other way. Let's see if it'll. That's so crazy. Nope. Let's see if they're on Justia. There we go. Idaho Code and statutes. Well, where's the statutes? Let's see. What do we got here? All right. Criminal Procedure, Title 19. Complaint and warrant of arrest. Person lodging complaint. Now, fully comprehend and understand this. When a complaint which has been subscribed to under oath by the party or parties lodging the same is laid before a magistrate, alleging facts constituting the commission of a public offense, it should be of a crime, tribal within the county, and the magistrate finds the complaint alleges a public offense under Idaho Code or county or city ordinance, the magistrate shall order the clerk of the court to file the complaint and refer the complaint to the appropriate county or city prosecuting attorney for further action. Well, wait a minute. This goes right back to the Criminal Practice Act of 1864, Section 102, page 226. There's the real statutes relating to the common law. This is a statute that is in derogation of the common law, and it most certainly follows the common law, because I've read it. I have it. So, they have subverted the Criminal Practice Act of 1864, which happens to be the second thing that the territorial or temporary government legislature created. It was the second thing. The first thing was the Civil Practice Act. But notice what this says here right after that. RS is revised statutes, then revised code, then codified law, section 7516, then codified statutes, Idaho Code annotated. First of all, you have no authority to revise the statutes. Statutes can only be amended. So everything from here on is void for any effect. Oh, look at that. The Idaho statutes come up now on the legislature's website. Let's see, will it do the Constitution? Might take a while. Yeah, they're playing games. Yeah, but again, who's lodging the complaint? It's got to be by the party, the injured party. But see, what do? They go, oh well, that's the county or city prosecutor does the complaint. And it sure in the heck can't be a policy officer now, can it? We already just went over State versus Clark. But there it is. You know, it's unlawful. But see, we have the right to file a complaint. And when we read Criminal Practice Act of 1864, Section 102, we find out that we're the complainant. That's the person is the complainant, the party, the injured party. But how many times have we all been told, well, you can't file a complaint. I'm the injured party. Of course I can file a complaint. I have the right to due process of law. Let's see. They're gonna... No, won't load the Constitution, huh? Although it loaded the statutes earlier when I went over here. Just will not do it, huh? Come on. My internet's fine. And it's worked plenty of times before. Just won't do it. But again, you know, when we read into this Criminal Practice Act of 1864, it does mention things like that the defendant can exclude people from the preliminary hearing, blah, 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 except for the complainant and his assistants of counsel. But then he goes on to says the attorney general, the county prosecutor. Well, wait a minute. Well, then who's the complainant and his? Wait a minute. We're supposed to even have the right to the assistance of counsel if we're the attorney, prosecuting attorney, the complainant. We have the right to prosecute our own claims. You know, we've been stripped of our rights and powers. They've got the system all set up, geared towards the people instead of protecting the people, and it protects the public servants. You know, and Trump has already said it many, many, many times. The judicial branch is corrupt. He knows. It's coming, folks. Make no mistake. Wish I could get to that Constitution. Maybe I'll come over here and find another place to find it. Huh. Secretary of State doesn't have a problem putting the Idaho Constitution out today. So where was that? Courts of justice shall be open to every person, and a speedy remedy afforded for every injury of person, property, or character, and right and justice shall be administered without sale, denial, delay, or prejudice. Where was that one where it talks about the people as a party? Maybe it is under the judicial. I keep forgetting where the heck that one was at. Okay, so under the Judicial Department, Article 5, forms of action abolish the distinctions between actions at law and suits in equity, and the forms of all such acts and suits are hereby prohibited. There shall be in this state but one form of action for the enforcement and protection of private rights or redress of private wrongs, which shall be denominated civil action. And every action prosecuted by the people of the state as a party. Oh, would that be what that means right here? By the party or parties lodging the same? Would that be the people as a party against a person charged with a public offense for the punishment of the same shall be termed a criminal action? But even then, I mean, those two go hand in hand, right? Party, people as a party. Jurisdiction of the district court. The district court shall have original jurisdiction in all cases, both at law and in equity. I thought there was no distinctions from the difference between the difference. But it's at law, at common law. Seventh Amendment suits at common law. That's the jurisdiction, common law and equity. They're doing neither. They're doing Roman civil law, the code. And see, look here. Jurisdiction of probate courts, jurisdiction of justice of the peace, repealed by general election. We can't alter our form of government like that. In 1961. Imagine that. So, I mean, that's the jurisdiction of the court. Common law and equity. Now, let's get down to the bottom here, because this is one that I have fairly recently discovered and is super favorite of mine. It's called Scheduling and Ordinance. Wait, what's that? Judicial proceedings continued, that no inconvenience may arise from a change of the territorial government to a permanent state government. In other words, no change. It is declared that all writs, actions, prosecutions, claims, liabilities, and obligations against territory of Idaho, of whatsoever nature, and rights of individuals and of bodies corporate, shall continue as if no change had taken place in this government, and all process which may, before the organization of the judicial department of the Constitution be issued on the authority of the territory, shall be as valid as issued in the name of the state. But see, you can't change that. Can't make those changes. Now, I guess in part this could be misconstrued as saying that, oh, well, that's for any cases or whatever, the stuff that happened before. No, it's not supposed to be any change. Because you're messing with a Republican form of government and the actual common law, due process of law. They have no authority to alter the fundamental law. But yeah. Yep. But, you know, Again, when we're looking at like the Idaho Code stuff here, this Criminal Practice Act, they you know, they show the history, and that's the issue, right? But then you get into some of the other stuff, then it shows CCP, the Code of Civil Procedure, Act of 1881, for the history. So, yeah, well, our the Criminal Practice Act of 1864, that doesn't have a sunshine. It doesn't expire. Trying to read the comments here. Whatnot. Yeah, Nancy out there on YouTube. I quit broadcasting on YouTube for a while because they kept trying to give me strikes and take out my channel. So, right, Jennifer. Yeah, we're supposed to have a true bill, right? Like a grand jury indictment, a true bill of indictment. Lee Zimmerman, how was camping? Camping was good. We ended up cutting it a day short because weather was rolling in, and we were sitting there, just basically got done having some dinner, and Thursday night we had planned to stay Friday, come home Friday, but we had checked the weather stuff out, and before we went up, we checked the weather forecast, and it said it might possibly rain Friday. So we're like, well, let's go. And, you know, if the weather starts rolling in, then we'll pack up and come home. Well, right after basically having dinner there Thursday night, about, I don't know, what was it? It was like, I want to say it was like 7:38. The wind kind of picked up. The clouds were kind of rolling in a little bit, and then all of a sudden the dark ones started rolling in. And they at first were kind of the white fluffy ones, but then they turned to the dark purple. Dark clouds started rolling in, and I was like, well, maybe we should pack up and go home tonight, even though it was kind of getting late. Yeah, it's a good thing that we did, because sure enough, it started raining. Actually, it started sprinkling Thursday night right after we got home. and I barely got my stuff up top unloaded. I just threw it in the garage because it was what 12:30 in the morning when we got home. But yeah, we decided to pack up, come home Thursday night because we didn't want to try to pack up in the rain Friday. But had a good ride. Some difficult single track trail there that we were on. One that we found last year. We did go on it. We knew it was a tough deal, but I did. Walking around, we tried to walk around the lake so we could get on the other side to do some fishing, because once we got up there, it was great. We wanted to take a little bit of a break, and took our boots off, took our riding boots and stuff off, and I had a backpack. My brother had his backpack, but we brought separate clothes so that we could do some fishing. And I brought sandals because I thought I was going to wade out onto the sandbar there until it got dropped off for the deep area for some actual fishing. And when we first got there, there was no wind. The lake was like glass. So we were sitting there, sipping on some drinks, and not alcohol, but flavored water drink stuff, and some snacks. And all of a sudden the wind picked up, and then it got really windy and choppy. I'm like, oh man, really? So we were gonna try to walk around the edge of the lake, and there's a little trail right there, and then the trail just died. So it's like, well, let's see if we can't just, because it got a little marshy right there. The ground was really wet, and so, well, let's just go in a little bit. Yeah, and we're in the mountains. Okay, there's a lot of freaking shrubs and trees and down trees and all that stuff laying all around there. So it started getting marshy, getting into some pretty wet stuff, standing water, pools of water here and there. I was like, oh man, this might have been a bad idea. But we knew about the actual the other trail, that it's a walking trail that goes around, because we actually took our dirt bikes on it, and that's pretty rough single track trail there. We ended up turning around and going back the other way and coming back up the other side. But anyways, yeah, I took a little spill off the top of a log there. I slipped off and skinned my ankle, kind of hurt my foot when I landed, bumped my other shin on the log when I fell. I was about 1.5 feet, 2 feet off of the ground there. I didn't necessarily get hurt because it was kind of cushioned there, other than my left foot. And yeah, I got lucky. But man, that was brutal, working our way up out of all of that and finding that trail up there. And we started hiking down the trail, got up to kind of a spot there where we could overlook, and we're like, oh man, how in the heck are we going to get out there where we wanted to get? It was like way out. There was no way to get down in there unless we hiked back through all that crap. I was like, never mind. We just turned around and walked the trail back. But yeah, Diesel D's, you made it. Good to see you, brother. Sorry it's breaking up. That sucks. Man. Yeah. Yeah, I know, Michael Casper. Yeah, why is it not super simple to get to these public corruption complaints. No, and I wasn't on the dirt bike when I fell. I was walking on top of logs down trees to work our way out of the marshy area. And it was pretty thick brush and trees to get through to up to the trail there. But no Superman maneuvers. I went down and gracefully. But yeah. Still was a really good time, and then made it to bed by about 3 a.m. And when I did wake up, man, I was sore as can be, my whole freaking body. I'm like, what the heck? We went hardcore riding Wednesday. I woke up Thursday morning. I wasn't really that sore. My foot was feeling it, my left foot, but yeah, my whole body was just sore. Probably from not just dirt biking, but everything else. Hiking, walking. But yeah, we found a nice little camp spot right next to basically where the trailhead was, instead of going over and across the street and up 4 miles. So we didn't have to ride our dirt bikes back down and over. We found those trails over there last year, so we definitely wanted to camp over there and explore quite a bit more. And there's a couple more trails in there we still didn't get a chance to go on, but we'll go back up. Right, Jennifer? Lucky for me, the ground was soft where I fell, and I didn't fall in between any other logs and bump my head or elbow or arm or break anything. Luckily it was a nice soft smushy landing there and not in a puddle, which it wouldn't have mattered. It would have dried out anyways. But oh yeah, and I had shorts on. And no Sasquatch sightings, no. Although we did have 3 deer come into the campsite, literally like 10 feet from us. Like, we even got up and like walked over to them. We had, I swear it was Big Mama Doe, and then at least a year-old buck and a year-old doe. And man, that one, it was first night, Tuesday night. I thought my brother was messing with me back behind the tent, because my brother likes to play games with me and try to, scare me or startle me or whatever, and so I just went over to the tent, go get my headlamp, and I heard something literally right behind my tent. So I was like, yeah, whatever, bro. And I come back out of the tent and went around. A deer standing right there, grazing, right behind my tent. And I'm like, really? And it didn't even like freak out, jump, or not, just kind of like, hey. So I got startled. I'm like, oh, okay. And then the next day, the buck, just sitting there, sitting in my chair, literally come walking up, grazing, looking over. So over by my tent. So my brother and I were like, well, let's see how close we can get. And we literally walked right over, right to him. He just kind of, we got a little too close, so he stepped over the log and then started grazing. And then the other doe the next day, we were sitting there eating. She come right up, right on the other side of the table. I could not believe that they would come up that close. But they know it's not hunting season, so pretty crazy. So got to see some deer up close that don't necessarily see, other than on the way home we had a whitetail. Those were all mule deers, and then a whitetail, which we took it really slow coming home because of the time of night it was. We saw one whitetail jump right in front of my brother, right, just leaving the camp, not even maybe 2 miles down the road. And then way further down the road, get down the road there, and there was 2 deer on the side of the road up next to the rock wall. Yeah, well, maybe out there in Mississippi they're scaredy cat deer, but here, I mean, typically, yeah, they usually take off, but man, yeah, the Tuesday night, the first one, they just kept going all the way around our campsite, hanging out, kept checking us out, grazing, and then it finally just wandered off. But yeah, I was relatively surprised to have them deer hanging out in the campsite with us. Obviously felt safe enough to hang around us. Yeah, Wendy, I actually tried to do that Thursday night. I really, really, really wanted to. We actually went up to the hot springs. It's right up there by where we camp. And Wednesday night, well, they closed at 6. So I'm like, I am going tomorrow night. 4:30 rolled around. I beat feet it over there. I get there. There's a sign that says closed for cleaning. Pool cleaning. Pool is closed for cleaning. I'm like, you gotta be kidding me. Really? So, yeah, that bummed me out because I really wanted to go sit in the hot springs there. Other than that, there are some other hot springs over on the other side of the mountain. If I wanted to go way up and around and over and back down, no. But it would have been nice. So I was double bummed because the first night we made it there too late. We literally pulled up there at 6:05. But we had a long day Wednesday. Like it was, man, it was, I don't know, what, 10, 9:30, 10 when we first took off. And we made it back to camp after the dirt bike ride and stuff. I want to say it was like 4:35. Yeah, it was like 4:30, 5 o'clock when we made it back. Yeah, it was after 5 actually, because we only sat there for about 15, 20 minutes relaxing, then changed our clothes and took off. And it's only, you know, 2.5 miles up the road there to the hot springs. So we were there in like 3 minutes. And it was 6:05. So it was probably closer to 6 when we got back, after 5:30 for sure. But thanks for asking, folks. And yeah, sorry about missing Wednesday night workshop again, but I really enjoyed. I slept really good this time. Got some really good sleep. It was super nice. A little bit of wind here and there. Lots of frickin' mosquitoes. Holy smokes. But after a while, I couldn't take any more getting bit. I've got marks all over my body here. Did some of the spray stuff, which I don't really like that much, but it works. So other than that, I'm going to call it a night, folks. Thank you all for being here. And if you like, follow, share. And if you'd like to help support my endeavors over here and help educating the people and leading people to the water, you can make donations over there to my Buy Me Coffee. Join my Patreon. Links are down in the description there. But I greatly appreciate all my current supporters and followers. Thanks for sharing and being here and wanting to learn. And we've got to come together, folks. We the people, all political powers and here the people, we have to come together. We have to stand as the people, not individually, not just one. So, but God bless everybody, and we'll see you Wednesday night for sure. Wednesday night workshop, unless something weird happens. But no plans not to miss Wednesday night workshop this week. So God bless. Much love, everybody. Have a wonderful night, and we'll see everybody else here Monday Night Law next week. All right? Maybe 4th of July weekend. I don't know. I'll see how I'm feeling for Monday next week. But if I'm not live Monday night, you'll know why. Holiday weekend. Might find something fun to go do. But anyways, good night, everybody. Much love. And we'll see everyone that's in Wednesday night workshop Wednesday night. All right.